Welcome to Gary Stern's webinar on reverse gifting, the new technique to reduce aggregate income and transfer tax liabilities and achieve wealth protection. Gary concentrates his practice in estate planning, wealth transfers, asset protection, taxation, international law, immigration law, corporations, partnerships, limited liability companies, mergers and acquisitions, and contracts. As part of his estate planning, wealth transfers, asset protection, and taxation practices, Gary works with his clients to implement strategies and techniques that can maximize a client's income and net worth. In the estate planning and wealth transfers areas, these strategies and techniques enable clients to reduce probate costs and lower estate tax liabilities on death. In the asset protection area, these strategies and techniques help clients to defend against unanticipated liabilities, litigation, and creditors. In the taxation area, these strategies and techniques assist clients to defer income, increase deductions, and lessen current income tax liabilities. Gary has been continuously elected to the leading lawyers network of Illinois every year since 2003. And now to tell you about reverse gifting, here is Gary Stern.
Thank you, and I want to thank everybody for being on our webinar today. I know we're all busy with our time, especially at 12 o'clock lunchtime, but I appreciate everybody taking time out. I'm going to go through the presentation. If you have a question, please send the question. I will respond to all questions though at the end, unless if it relates to something specifically that I'm talking about, then I'll try to respond sooner, but I will try to get to all the questions at the end. So for reverse gifting, reverse gifting, to really understand the concept of it, one needs to go back and understand gifting as it's been used on a historic basis. So when we talk about gifting, we're talking about transferring assets typically from the senior generation, be it a grandparent, be it a parent, to a junior generation, children, grandchildren, nieces, nephews. The goal of gifting really derives initially from a desire to transfer assets to another beneficiary. But really there have been three common purposes that have historically driven gifting to be an estate planner's tool. The first one is estate tax minimization. The gifting exemption, there are two exemptions for estate tax purposes that we commonly talk about. One is the annual gift tax exclusion. When I started in practice many years ago, that was $10,000. It's increased over time. It is now $14,000. So each person can gift $14,000 per year per donee. There is also what we refer to as the lifetime gift exemption. The estate laws and the gift laws are now together unified so that there is an exemption under current law of $5,250,000. That can be used at death to avoid estate taxes. It can be used on an inter vivos basis during one's lifetime for taxable gifts, otherwise taxable gifts. So when you're doing gifting, what you're really saying is you're almost pre-funding an inheritance. But by doing it, by taking advantage of these exemptions, you're taking assets out of the estate before the estate tax would be due. You're not only taking the assets out of the estate, you're also taking the appreciation on those assets. So if I made a gift today of $14,000 to a child, that $14,000 is out of my estate. But if that asset grows and is $50,000 at the time of my death, I've taken $50,000 out of my estate, not just $14,000. So for estate tax purposes, gifting has always been a key feature as a way to try to minimize the estate taxes on death, federally or also states, to the extent states impose an estate tax. Second reason, or the second motivation for doing gifting, is income tax minimization. When we talk about income tax minimization, we're really concerned or based on the fact that our income tax system is a graduated rate system. So generally, in most cases, senior members, parents, grandparents, have a higher taxable income than do children, grandchildren, and are subject thereby to a higher marginal income tax rate. So if I'm able to take an asset that's producing income and move it to my child, whereas the income from that asset when I owned it pre-gifting would maybe be taxable to me at a 35, 37, 39% rate. State taxes would be imposed as well. My child may be subject to taxes at a 0, 5, 10, 15% rate. So I'm able to achieve what we call income shifting and also income tax minimization. Now, as many of you obviously know, the kiddie tax that's been imposed in recent years helps to mitigate that planning to a certain extent, and you're really talking about an adult child. But even an adult child in many cases, particularly in today's uncertain job market, may be of a lot lower income position than may be the parent, or the grandparent. The third reason that gifting historically has been done is what we would call for wealth protection purposes. And basically, when we talk about this, most cases, not always, but in many cases, our children or grandchildren are less likely to be subject to a lawsuit, to be sued, than is the senior generation. Now again, when we talk about wealth protection, the governing law is always going to be fraudulent conveyance law. And even in the gifting area, nothing can be transferred, nothing can be moved to another beneficiary without making sure that there is not an existing creditor that you're trying to thwart or prevent by making the underlying gift. But assuming this is a case where there is no fraudulent conveyance limitations and you're able to gift, the benefit of a gifted asset being in a child's name relative to a parent's name can be significant if the parent is going to be sued. And in fact, there is various case law where judges have ruled that estate planning, and estate tax minimization is part of estate planning, is an objective, a purpose that can rebut a fraudulent conveyance claim by a creditor. So to the extent that you're actually implementing gifting as part of an overall estate plan, makes it harder for the creditor to argue you did this just to thwart the creditor, just on a fraudulent conveyance basis. Okay, so in recent years, we're seeing that traditional gifting may become somewhat less important. Now, one thing to keep in mind that has always been an issue when we talk about gifting and making gifts, step up in basis of assets. So, traditionally when we're talking about senior to junior generation, there's two ways to pass assets. Through an inter vivos gift during your lifetime, on death by inheritance or bequest or some other means passing at the time of somebody passing. When an asset passes on death, the beneficiary of the asset gets a step up in basis. So again, I know this is basic maybe for some of you, but just so everyone's on the same page. So if I bought a piece of real estate at $10, and when I die that real estate is $50, when I die my beneficiaries will have a basis in that asset of $50. That can be of critical importance because that step up in basis will mean that when they sell the asset for $50 at its then fair market value, they won't have any taxable gain to report. On the other hand, if that $10 basis asset was gifted to my beneficiaries before my death, they would not get a step up in basis in the assets. They would have a $10 basis, and then if they sold the assets, they would have to pay capital gain, ordinary income, whatever it may be, on that $40 differential. So gifting has always had that negative component that when you sell assets post-death, you don't get a step up in basis in the assets. Now, for many times when the federal estate tax exemption was much lower, even as of a few years ago, $1 million or in the $3 million range, the ability to avoid estate taxes, given that state tax rates were higher, in many cases the estate tax base, because it's really a tax on net worth, was higher than the potential income tax. For most people, if you think about it, your net worth is higher than your taxable income. So for those reasons, most times the estate tax planning drove the issue, and the no step up in basis was not that significant. Well, with an increase in the federal estate tax exemption now to $5,250,000, the whole notion of gifting has kind of changed, because with people otherwise being able to exclude estate tax liability on a larger amount, they less need to do estate tax planning to minimize their situation. Just recently, we did earlier this year look through our clients and found that the increase in the exemption to $5,250,000 probably excluded an additional 20% of our client base from estate taxation. So gifting still may be motivated for other reasons, but there's maybe less of a reason to do it for estate tax minimization purposes because you have the exemption. One other point is that portability is now something which is under the estate taxes. And while that's not a main subject of our discussion today, I can cover it if people have a question about it. Portability, also put into the law under the prior changes in the estate tax law, also has the effect of minimizing estate tax liability. So with these changes taking place, gifting is important. The other factor to note about gifting, when you're talking to a client, and very commonly the client will say to you, well, if I gift this asset, how do I get that asset back? How am I still able to utilize the asset? And we say, well, Mr. and Mrs. Client, the point is it's not your asset anymore. They actually own it. In a true sense, for the gifting to work, they have to be the owner of the asset. Now, as planners, we mitigate that issue by gifting minority interests in entities, so no one can control the entity. We gift limited partnership interests in limited partnerships where the general partner controls the entity. We maybe gift the asset in trust, so somebody else is managing it for the beneficiary. And those things mitigate the issue, but the point of fact is you're doing a financial statement. You're selling something and distributing cash. For the gifting to be respected by the Internal Revenue Service, by a creditor, for those reasons, the junior generation really needs to own that asset. Family dynamics being what they are, in many cases, that's a big concern for clients. And clients do not want to have their kids, their grandchildren owning the asset. Even if many cases they trust the child, the concern is, well, what if my child gets divorced? Is that a non-marital asset? And again, not the main focus of the discussion, but while gifted property is generally treated under state law as non-marital property, you still have issues that have to be addressed. So traditional gifting probably is not used as commonly today as maybe it was used 5 years ago because of these factors. Okay, so I'm now going to turn to the main topic of our discussion today with that background in mind, and that's reverse gifting. And reverse gifting, and I'm sure someone will come up with some cutesy marketing name for this better than reverse gifting, but I guess I'm just not cutesy or marketing in that sense to do that. So we're just going to define reverse gifting as gifting from a junior generation to a senior generation, or maybe more specifically, gifting assets to a person who, based on life expectancies, is more likely to pass. So the donee more likely to die than the donor. Now, at first blush, you'd say, well, why would I want that? Because potentially I have an estate tax then being triggered. And that, in fact, is the whole concept behind what we're saying with reverse gifting. What we're doing here is we are moving assets into somebody's name who's less likely to have an adverse consequence take place. Now, believe me, death is an adverse consequence. Yes, I know that. But in terms of the planning aspects of this, what we're trying to do is say that the ownership of this asset is now in the hands of a senior generation. So I'm going to go through a number of examples, and while this can apply in other family situations, I'm going to take the case of child and parent. Child, the junior generation, parent, the senior generation. And let's say child is age 50, parent is age 80. So again, we don't know the vagaries of life in the world, but generally most likely the parent is going to pass before the child is going to pass. Now, one thing that will be done in conjunction with reverse gifting is you're always going to want to do something here, because reverse gifting is really almost a transitory form of gifting. in the sense that ultimately you'll see the asset is going to go back from the parent to the child. So when we do reverse gifting, it's really a two-step process. One is gifting the asset from the child to the parent. The second step is amending that parent's estate planning documents to ensure that on the parent's death, that asset is going to transfer back to the child. So think of it as, again, a two-step transaction taking place. Gift, child to parent, step one. Parent dies, asset goes, parent to child, step two. So you're able to basically take advantage or implement those two different steps. Okay, so what are the specific advantages of reverse gifting? Okay, let's say that child, go back to my example from earlier, has an asset that is $10. But now the fair market value of that asset is $50. If the child was to go and sell that asset, you'd have a $40 capital gain. You'd have $40 of ordinary income that the child would have to deal with. But let's say the child gifts that asset to the parent. Now, parent will take a $10 basis in that asset because $10 on gifts is what we call a carryover or substituted basis. Parent then dies. And again, in my example, let's assume that the parent has amended their estate plan so that that asset is to go back to the child on the parent's death. So when that asset passes back to the child on the parent's death, the child will get a basis in that asset of $50. The child then goes out, sells the asset. Child has avoided paying any capital gain or income tax. That is the key factor driving reverse gifting. A way to sort of say, in the overall family unit, how can we reduce aggregate transfer tax liabilities? Now, the key in this is that when the senior member dies, that is not going to be a taxable event to the senior member. Or we're really saying that the estate tax exemption available to the senior member in that situation is in fact then of a sufficient amount so that there will be no estate taxes payable at that point, i.e. taking advantage of the higher $5,250,000 exemption that's going to exist on their death. Okay? Now, what assets is this going to make most sense for? Well, really any appreciated asset that the child is thinking of selling or will be selling, you can benefit from the reverse gifting. Because what you're trying to do is avoid that potential appreciation, that paper gain that exists on the asset by moving the asset over to the parent and then on death having it pass to the child. Now, obviously, we don't know when death is going to occur. You know, you always have that uncertainty. We're going to talk in a few minutes about a limitation under the Internal Revenue Code that you have to generally wait 1 year for this to be implemented. So if the child is going to sell something in 20 days, 30 days, probably not an effective way to do things. Like all planning requires some forethought, requires some concept of what you're going to implement. But in terms of the asset that you're talking about, any type of appreciated asset. Many times subchapter S stock in transactions is limited in one form or another. Here, asset owned by an individual, the child, asset owned by an individual, the parent, asset owning back to the child, subchapter S stock, no problem with this. LLC interest, general partnership interest, brokerage accounts, real estate. Anything that's going to have appreciated property connected with it should be able to be implemented in this transaction. If you have appreciated property with a liabilities in excess of basis issue, there may be some special planning required than that. As we may be aware, when we gift something that has liabilities in excess of basis, there could be consequences to have to deal with at that point in time that have to be implemented. But in most cases, it's something that should be able to be implemented by the parent and the child. One final point about this. When the child makes the gift of the asset, the child is going to be utilizing part of their estate tax exemption, because that, well, I should say, part of either will be using part of their estate tax / gift tax exemption. If it's only a gift of $14,000, then maybe it's their annual exclusion. But that gift to the parent will have to be accounted for, because we want to treat it as a gift, so it is in fact going to be part of the senior parent's estate, so when they die, there'll be a step-up in basis in the particular assets. So this is what we talk about, as I said before, the aggregate transfer tax liabilities for the family unit being reduced. You know, if the child is thinking that, well, the exemption right now is $5,250,000, it's tied to inflation, that amount is going to continue to go up. So while as we're sitting here today, as people listen to this in months in the future, hopefully there will be a federal government when you're listening to this, but generally the desire for revenue notwithstanding, I personally don't see that there'll be a significant reduction now in the estate tax exemption. But again, those factors have to be factored in. Look at the effect of the gift to the child as well. Okay, so reverse gifting is not only beneficial from an estate tax minimization perspective, it also has two other advantages. One is what I'm going to call temporary income tax relief. What we're saying by this concept is, and really this concept and the next concept I'm going to mention, this kind of builds more on the senior generation being viewed as sort of this transitory owner of the asset. And when I say transitory, I don't want to get the wrong impression. For ownership purposes, this will involve a retitling of the asset in the name of the parent. So, you know, it's not a nominee, it's not a sham. The parent really is owning the asset. But while the parent is owning the asset for the rest of their lifetime, if they are in a lower income tax bracket than the child is, and again in my example where you're talking about an older child, 50, who we hope is doing well and has a decent taxable income by that age, they will be in a higher income tax bracket than the 80-year-old who's retired, maybe on Social Security, maybe living off of investments. So the ability to transfer the asset to the senior generation, have income tax paid at the parent level, the senior generation, lower marginal rate, can again result in reduced income tax liabilities for the family unit. Now, the issue here obviously requires a relationship between parent and child where they get along, they function, they can view their planning in an effective, interactive manner here. Many times the senior generation will pay that tax liability. Many times the junior generation, the child, will pay that tax liability for the senior generation, for the parent, because it's beneficial to them that they're still paying at a lower rate. Obviously the payment of the tax liability could trigger another gift that has to be dealt with as part of the planning. But the overall numbers, the overall situation is such that you still have a case, you still have a situation where you can result in income tax relief. You know, today, income tax rates, maybe you have 15, 20% differentials. If the income tax rates go higher, differentials become more significant, the planning could become more significant. Another point to consider is what we would call temporary wealth protection relief. Again, subject to the basic caveat here of can't do anything that's going to be a fraudulent conveyance, violate the fraudulent conveyance laws. But let's say, for example, I am, or the child in this case, is a physician, and the child is 50 years old, and the child just, in the nature of their profession, understands, feels that there is a risk of liabilities that they could go through over the next 10 years. By taking an asset and putting it in the name of the non-physician parent, who's less likely to get involved in a lawsuit, less likely to be sued, won't be sued for malpractice, not a doctor, generally less likely to be subject to creditors, there can also be relief. Now again, the key point here needs to be that purpose, what is the purpose of the transfer? It's always been sort of interesting when you're dealing with these issues. When you're talking to the Internal Revenue Service, asset protection is your business purpose, and that helps to undermine or an argument that this was done for tax purposes. On the other hand, when you're sitting with a creditor, your purpose is tax planning, and for that purpose, so you're able to undermine or try to undermine an argument this was a fraudulent conveyance situation. So again, what we're trying to do here is justify transactions, but nowhere here are you able to avoid the basic fraudulent conveyance limitations that exist. It has to be done again with advance, with pre-planning. Okay, so we've highlighted the advantages of doing a reverse gifting transaction. Obviously, nothing is perfect, and there are disadvantages that come about from reverse gifting. One of them, maybe not a disadvantage as much as a limitation, is under Internal Revenue Code section 1014E. And I'll read it just because I think it's important that everyone understands it. There is basically no step-up in basis of assets if, quoting, the appreciated property was acquired by the decedent by gift during the one-year period ending on the date of the decedent's death, and such property is acquired from the decedent by the donor of such property or the spouse of such donor. So what this is saying is that, again, going back to my example, if the child gifted the asset to the parent January 1, 2014, and the parent dies anytime prior to January 1, 2015, you will not get the step-up in basis benefits of reverse gifting. So there's that one-year look-back period. So again, the goal here is this is not a deathbed transfer situation then. You have to have some foresight in your planning to understand when this situation would be beneficial. Now, a couple of things here. 1014E specifically just applies to a step-up in basis of assets. If you were to make a transfer on January 1st, 2014, the child makes the transfer to the parent, and the parent dies July 1, 2014, you're not going to get a step-up in basis of assets. Will you get the temporary income tax relief for those 6 months? Certainly 1014E doesn't limit you. Could the IRS make an argument that this was not what we call an old and cold transaction, that 6 months is not enough? I think 6 months is generally going to be enough. The other objective or the other purpose of reverse gifting, as we saw, in terms of making a transfer to avoid a creditor in a non-fraudulent conveyance situation, is 6 months of ownership going to be enough? Well, if you can establish that this was true ownership in those 6 months, deed was in the parent's name, assignment was in the parent's name, any income that came out, distributions went to the parent, not to the child, I think you'd have a good argument of doing that. So even if 1014E applies, there still may be benefits from reverse gifting. Now, the more interesting aspect of this, because of course as planners we look at code sections and try to drill holes in them if we're able to, is the notion here of the language at the end that refers to the property being acquired from the decedent by the donor of such property or the spouse of such donor. So clearly the child's wife or husband would not work for 1014E. But what if the child transferred the asset to a brother or sister? Or what if the 50-year-old had a child and the grandchild transferred the property? 1014E, the language of it, obviously very limited authority interpreting this provision when you look at it. Would that be a way to get around 1014E? Again, with gifting, using a child, so let's say in my example, the grandchild is 21, so they would have authority to sign documents. Well, you're then utilizing the grandchild's potentially $5,250,000 exemption, or their $14,000. It involves getting the grandchild involved as part of the planning. Again, is that significant? If you have a lot of appreciation on assets, could be significant. The whole concept of appreciation is always kind of interesting. In recent years, with the financial crisis of 2008 and particularly with real estate, not too many clients come in complaining about appreciation in property. Of course, 5 years before, that's all they were concerned about was appreciation and avoiding the capital gain. So again, right situation for any type of planning. You need to have a significant amount of appreciation. The only point I'm going to make now is simply that there does appear to be some get around this provision even with a deathbed transfer. Now the other side of it, a truly deathbed transfer where you make the gift and the parent dies the next day, does that meet the old and cold rule for IRS purposes? Probably not. More specifically, can a creditor undermine that? Well, the creditor situation, maybe it's what benefit are you really getting because they die and then you're the beneficiary. You avoid a creditor for 1 day. Probably not that significant anyway. So, but those factors all have to be analyzed and looked at, and the general concern of the situation here is always, what is the rationale? What are we trying to accomplish here? And can it make sense in the overall facts of the transaction? Another issue that when we're talking about reverse gifting is how or what is the implications of the senior generation actually owning that particular asset. So what we're saying here is, how can the senior generation best own the asset? And one concern is, well, if the senior generation owns it in their name, what specifically is the mechanism by which it's going to come back to the junior generation? The junior generation wants to make sure they're going to get the asset back. Well, as I said before, we're going to amend the senior generation's estate plan, and it's going to say, and hopefully be properly worded, this asset comes back to child. Obviously, when you have multiple children, you need to be very precise in your language. The default descendants per stirpes clause probably is not going to work. You're going to need some effort to try to deal with that. But even beyond that, one thing that's a concern always with seniors is the risk of them being manipulated in some way. And situation would be child one enters into this planning with parent, and child two, the evil bad child, either before or after enters into a power of attorney with parent, whereby child two gets control over the asset, and the asset gets distributed to child two. And child one has a lawsuit, but doesn't have much except a lot of legal fees and doesn't have the asset in their particular name. So giving an asset to a parent directly is a concern. Probably the more effective way to make the transfer is by making the transfer to the parent in trust, with you as the child one in my example, being the trustee over that trust. Still can be an effective gift if drafted properly, that you just have fiduciary control over the asset, but will not be part of the child's estate in any way, isn't the parent. Trust provides on parent's death. Trust provides on parent's death for the property to come back to child one. So they're definitely able to get the asset. Now, trust, obviously, the negatives of a trust. How is that trust going to be taxed while the parent is living at that point? Well, one thing you could do is, if the concern is step-up in basis and not the temporary income tax relief, you could make it a grantor trust. So as we probably know, grantor trust taxable to the grantor, income tax attributes taxable to the grantor. So the child could still pay income tax liability on the assets that are going into the trust. That's one way to handle it. You could also have the trust as a taxpayer, where the trust is actually paying its own taxes. As people probably know, trust income tax rates are generally not as favorable, particularly at lower levels of income, than our individual income tax rates. And as a result, that issue would have to be addressed also in terms of how the trust is going to be taxed to the individual. If you're gifting interests in entities, you may be able to put things in a shareholders agreement, a buy-sell, an operating agreement that also can prevent the senior member from ever losing ownership of that asset. So again, variety of different options. Have to look at the particular planning situation for what you want to try to implement. Two other concerns with the senior generation owning the asset. Nursing homes, and again an issue for seniors going into a nursing home, tend to be, and hopefully I'm not insulting anyone out there, but very predatory, shall we say, in their creditor aspects of trying to make sure they get paid and getting the assets of seniors. Medicaid reimbursement is another often related issue to that. I always chuckle that the only creditor in the world that is able to get a 5-year look-back period to reclaim assets is the nursing home industry. So they certainly have exercised their political muscle accordingly in doing that. So the point there being that if the senior goes into the nursing home, you may have an issue with trying to keep that asset out of their clutches so that that asset can in fact come back to the child on the parent's death. A trust, properly drafted, again with enough foresight to do it 5 years in advance of getting in there so you avoid the Medicaid reimbursement issue, can be definitely one structure that can be utilized. Special needs trust can also be utilized for this purpose to try to mitigate the risk of the asset not coming back. The other concern here is probate. If the asset is in the senior's name and they die, that will be a probatable asset. Now, again, we recommend for all individuals, really at any income asset level, that a living trust be done to avoid the probate issue. I know there's people on here from different states. In Illinois, if you're in Cook County, probate is a nuisance. Not the worst thing in the world, it's a nuisance. I know other states like New York, California, probate is a much more significant cost issue as well in terms of court fees, what the lawyer is going to charge, etc. So those issues have to be considered, but then just simply, once the asset goes into probate, it's more of a free-for-all in terms of who's going to get it. Is a creditor going to make a claim against the parent? Are there other claims that may be out there with, second spouses, other children, whatever it may be? So again, even if you're not going to go the way of having a formal, grantor trust and a trust of that type, even a living trust would have the benefit of having probate be applied and thereby having probate be avoided and thereby enable the reverse gifting to achieve its intended purpose that's going to apply there. One question that I see that kind of relates to this topic, so I'll address it now. Question is, if you have Medicaid reimbursement or nursing home problems, how do you avoid that issue? Well, that's not really the topic of the discussion today, but there are various ways to deal with that. The key to that is that there's a fair market value exception to the nursing home and Medicaid reimbursement. So what planning technique that's often utilized is find fair market value ways to take assets out of the senior member's estate, out of their name. Many times a services agreement, a consulting agreement where the parent and child will basically contract one for the other provides a technique that enables you to be able to do that. So hopefully that answered the person's question with that. Another question, has this ever been tested with the IRS? The question really here is, we have done reverse gifting transactions really as part of other planning. It's not something per se that is tested if you're talking about the reverse gifting, because the point is, it's like saying, is any gifting that's going to be tested? why would any gifting where you gifted something to somebody, they held it for a period of time? The only limitation that the IRS has asserted in terms of Internal Revenue manuals or other things that we've seen from agents is the application of 1014E. And I will say that we've done reverse gifting. I'm thinking back in 2 situations where the person died in a 1014E case, and we didn't take the step up in basis because obviously we're not going to violate what is a clear Internal Revenue Code section that's going to apply. Okay, so in summary, and then we'll take some more questions and answers then, but in summary, what we talked about today is the following. We sort of explored gifting historically, saw some of the reasons, rationales for doing gifting transactions, then went into why traditional gifting may not be as important today, the no step-up in basis limitation, the higher exemption from liability, so that maybe there's less of a need to engage in gifting transactions. And then we went into reverse gifting and kind of saw reverse gifting as a way by which you could transfer assets differently than has been done historically. That basically the child would gift assets to the parent for 3 objectives. 1, to get a step up in basis in those assets on the parent's death, so if they sold the assets then they would mitigate their tax liability. 2, is there some temporary income tax relief while the asset is owned by the parent that income taxes will be less? 3, is there some wealth protection benefits that can come in that a creditor would not be able to access the assets? We talked about 1014E, that clearly on the step-up in basis issue, you need to have a 1-year waiting period. Less clear regarding the temporary income tax relief or the wealth protection relief. We talked about the best ways to transfer the asset to the parent, and the specific motivation of doing that, trying to make sure the asset is going to come back to the child in the particular situation. So that is kind of our discussion for today. I see a few more questions have come in. I'm going to address those now, and then please keep the questions coming. We have a good turnout today, which is nice. So, if you have other questions, send them on. We'll stay on probably for another 10 minutes or so answering questions. So the first question, which is I'm sure on many's mind the most important questions, do we get CLE for this? And we are in the process of getting CLE. Actually, it says CPE. I guess I should say, since it's an accountant, CPE, not CLE credit. And if you email me with your information, we can follow up with you to make sure that you do get, the appropriate CPE, CLE credit for the transaction. Second question that was asked, do you utilize grantor trusts on a regular basis? Well, here we're talking about grantor trusts in the case here with the reverse gifting. Grantor trusts have the advantage of being taxable to the grantor. That is advantageous in many different situations. For example, just something I just finished last week, QPERTs, Qualified Personal Residence Trusts, which are another common estate planning technique, whereby you basically gift your residence to a trust for a term of years. And at the end of the term of years, that asset is no longer owned by you. It is owned by children or other beneficiaries. The advantage of the QPERT being a grantor trust is that while the asset is in trust, you have to pay real estate taxes, you have to pay other expenses that maybe would create a tax attribute or a tax deduction. With it being a grantor trust, you're able to have that asset then come back to the grantor, and they still get the benefit, the income tax benefit of the real estate tax deduction. So, grantor trusts are used in other situations as well, where very simply there's a benefit in having the grantor being taxed. A lot of grantors say, well, I don't want to be taxed, but if you think about it from an estate planning point of view, if the donee of the asset is avoiding tax, you're really increasing, augmenting the gift that's going to that particular person. So you're able to increase, the ultimate tax benefits that are being able to be, realized. Another question, how are reverse gifts treated under state law? Well, there should really be no difference why reverse gifts would be treated differently under state law than under federal law. Here in Illinois, as we hopefully know, there's a state exemption of $4 million, a little different than the federal exemption of $5,250,000. But again, certainly a lot larger exemption than there has been, in prior years. So no reason why the same concepts for reverse gifting should not also apply for Illinois purposes. One thing we see in our practice is that state taxes have definitely increased around the country. Illinois raising their rate to 5%. So, certainly there is more of an issue with state tax liability, and therefore the income tax benefits from reverse gifting, may become, more significant in that way. Next question, how is reverse gifting treated for generation skipping purposes? So under the generation skipping law, again, we could talk for an hour about generation skipping tax, but very briefly, in the case where there would be a gift from a parent to a grandchild, from a grandparent to a grandchild, or really in this case, on the death of the grandparent going to the grandchild, you could have generation skipping tax liability to deal with. Some clients seem to think generation skipping tax was repealed. It is still totally part of the law. The higher exemption extends to that as well, that there's a higher exemption today. But, that issue would be dealt with as part of the GST. Shouldn't change any of the planning possibilities discussed here. Okay, I'll take a couple of more questions. Are there any facts and circumstances IRS risks? Well, to me, the IRS risk would be greater the shorter the time periods between each transfer, because the transitory ownership becomes, more of an issue, more of a concern then. But again, the key thing you want to demonstrate, while gifting can take place for many purposes orally, we always want to have a written document. So if we're talking about real estate, you want to have a deed transferring the asset. Not just signed, but notarized, recorded, whatever the appropriate jurisdiction is, so you've made a valid transfer of that asset. One thing always to be concerned about when you're dealing with real estate, transfer tax liabilities. If it's an assignment of an interest in an entity, again, that the assignment be prepared accordingly, assignment of members' interest, assignment of partnership interest. The K-1 then, at the end of the year, gets issued to the parent as, in fact, the correct owner of that particular asset. So, one thing we're always very big on is, the documents have to follow the intent of the client. So you do have to structure this or set something up whereby everything is going to be consistent. The more you're able to do that, the risk, the IRS risk, is thereby mitigated, significantly. Well, I think we are out of time now, so there we go. Okay. You'll see on the slide now my email address and phone number. Certainly feel free to follow up with me afterwards if you have any questions, either by phone or email. And again, thank you for your time today, and we will be doing more webinars in the future, and hope to be speaking with you again soon. So thank you again very much.